The value of property before the taking is a key element in just about every eminent domain case. Under Michigan law, property must be valued based upon its highest and best use, not its actual use. Property owners who are choosing not to use their property in a maximally profitable manner are not punished. There's a multi-stepped process of evaluating highest and best use. One of those is whether a particular use is legally possible. It's fairly common to evaluate the reasonable possibility of rezoning a property to meet that test. In some instances, you can also evaluate whether the reasonable possibility of obtaining a zoning variance helps meet that test to establish a higher, more profitable, more valuable highest and best use. In the 1990s, the Michigan Department of Transportation engaged in a major project to widen Hall Road. They installed 4 lanes of traffic in both ways and turned it into a very wide boulevard. They required the acquisition of property all along the frontage on both sides of the road, deep into commercial properties. Behind me is one of the access points to what used to be an Art Van furniture store. As a result of the taking, the store's access points were no longer compliant with its site plan. The Michigan Department of Transportation sought to introduce evidence that it could obtain variances to offset the impacts of the legal nonconformities. There's a long line of cases allowing property owners to submit evidence about the possibility of rezoning, and the Department of Transportation analogized those cases to being able to obtain a variance. In that situation, the court allowed the evidence to be introduced. The evidence that MDOT sought to use to establish their point were prior zoning variances granted to similarly situated properties. Since that time, the Uniform Condemnation Procedures Act was amended. MCL 213.54 now allows agencies, and only agencies, to obtain what I like to call super variances to cure nonconformities. It's my position that the Art Van case is no longer applicable to situations in which the agency seeks to introduce the reasonable possibility of obtaining a variance to cure just compensation issues. Rather, the agency should either obtain or have their application rejected. However, the precedent, in my opinion, still remains valid in terms of property owners being able to demonstrate the reasonable possibility of obtaining variances to establish a higher before taking value. As you can see, it's important to not only understand these legal concepts, but the order in which these concepts were implemented. It's necessary to know that the reasonable possibility of a variance before the taking is something that can be considered by property owners to increase the value of their property, but the reasonable possibility of obtaining a variance is not something that agencies can assert after the taking in an effort to reduce payment of damages to the remainder.